Welcome to Assignment 1, Case Briefing. The class lecture will discuss the importance and fundamentals of case briefing in law school. The roadmap for this module is as follows. What is a case brief? Why do we case brief? How do we do a case brief? And finally, an application of a case brief. So what is a case brief? A case brief is simply a summary of a legal case that was resolved through the court or judicial process. Why? Why do we case brief? Before you begin to brief a case, it's important that you understand why you brief a case. Law students and lawyers brief cases for a number of reasons, but the main reasons are as follows. To organize and keep track of your research. A legal memo may require that you cite multiple cases to support your argument. Therefore, briefing a case helps you organize them by relative weight, i.e., which cases will help go against your case argument or which cases will help support your argument. A case brief also helps you form legal analysis to support your legal argument. Finally, case briefs help you and lawyers predict a client's chance of success by knowing the existing law or precedent on the legal issue. Now, how are we going to brief a case? The meat of a case brief is as follows. Facts. Which relevant facts did the court use to make its decision? Issue. What did the parties ask the court to decide? The holding or the decision of the case is the court's specific answer to the questions presented by the issue. For example, we reversed the defendant's conviction because the evidence was insufficient as a matter of law. Procedural posture. Here we want to identify the parties in transition of the case through the court or judicial process. If it's an appeal, what was the lower court's ruling, what issues are being taken up on appeal, which party appealed, etc. The legal rule. Unlike the holding, which applies to the case at issue, legal rules are generally applicable. Both judges and attorneys take legal rules and apply them to the facts of a particular case. Finally, application and reasoning. Judges and lawyers apply the facts to the legal rules and vice versa. The application leads to a holding. In other words, why did the court rule the way it did? Because you're new to briefing cases, don't worry about getting it completely right the first time. Instead, focus on understanding what's going on in the case. At first, you may need to read the case twice before actually starting, and that's normal. Don't worry. The more you practice, the more you become comfortable at reading and briefing a case. Soon you will start to recognize patterns in the way cases are written, you become more familiar with legal words, legal writing, and briefing will become second nature. Now let's practice the basics of case briefing. And we will start with Washington v. Barnes. So what are the important facts that we've gathered here? First, Barnes attempted to steal the plaintiff's lawnmower, claiming he was ordered to take it to someone at a pumpkin patch. Barnes was charged with the theft of a motor vehicle and driving without a valid license. Now, the issue is whether riding a lawnmower qualifies as a motor vehicle for purposes of the Washington statute, which is a person is guilty of theft of a motor vehicle if he or she commits theft of a motor vehicle. Note, you may want to get comfortable distilling the issues in your own words, and don't be relying on exactly word for word what comes out of the court's mouth in terms of the issue. Try rewriting these parts in your own words to get comfortable with reading and framing the issues in your own mind. We continue to the main part of a case brief. What was the holding? The Supreme Court of Washington upheld the appellate court's ruling that a lawnmower is not a motor vehicle for purposes of the Washington statute. Fascinating. The concurrence here agrees with the majority decision, but in other instances, the concurrence would have its own section if it differs from the majority. Procedural posture. The Washington trial court dismissed the theft charge because a lawnmower is not a motor vehicle, according to the trial court. The case was appealed to the Washington appellate court. The appellate court upheld the trial court's ruling. The state now seeks discretionary review from the Washington Supreme Court. So that's how we got here. The rule to take away from this case: a riding lawnmower is not a motor vehicle for purposes of theft. How does the court apply it? Well, the Washington legislative intent for enacting the statute was a response to rising automobile thefts on the nation's west coast. The bill referenced the family car as essential to families. When stolen, it causes financial hardship and negatively impacts a family's ability to commute to work, school, and other personal activities. So in continuing this application, the court found the plain meaning of the word motor vehicle means every vehicle that is self-propelled. But an electric personal assistive mobility device is not considered a motor vehicle. For example, a power wheelchair is not considered a motor vehicle. So a thief can steal and quickly escape in an automobile, motorcycle, truck, or even a four-wheeler, but not necessarily in a riding lawnmower, asphalt spreader, or skid steer. So now that we worked through a case brief together in Washington v. Barnes, let's take a minute to apply what we've learned in that case. We will be using a contracts case you are likely to cover this semester, Lucy v. Zemmer. This case is a great reminder to never conduct business deals on a restaurant check or in a bar while drinking whiskey, for that matter. Remember Washington v. Barnes and Washington v. Barnes, what we want to take note of. The case name, citation, facts, procedural facts, issues, rules, application analysis, conclusion, and holding. So we already have the case name, and that's Lucy v. Zemmer. The citation is 84 Southeastern Reporter, 2nd edition, page 516, Virginia Supreme Court, 1954. So let's go to the facts. What key facts do we need to take away from this case? Remember, in briefing, it's not necessary to write down every single fact given in an opinion, nor is it appropriate to copy the facts section word for word. Come up with a good synopsis of a case that allows you to understand how the law was applied. As a bright-eyed and optimistic 1L, myself took down about a full page of factual notes in case, and while I was prepared to recite the case for Professor Carrata, that's not something you want to be doing in every single case, as it's not a good use of your time. So an example of the facts that you want to take away from this case, Lucy v. Zemmer, are as follows. Lucy walked into a bar in rural Virginia where he saw Zemmer. The two had known each other for years. Zemmer owned a large farm in Virginia called Ferguson Farm. The two talked for roughly 45 minutes and were drinking. Lucy claims he was not intoxicated, while Zemmer was as high as a Georgia pine. Lucy attempted to buy the farm in the past, and his most previous attempt was about 7 or 8 years prior in a verbal offer of $20,000. While in the bar, Lucy said something to the effect of, "I bet you wouldn't sell it for $50,000, to which Zemmer challenged if Lucy could produce that kind of money. Lucy told Zemmer to write up an agreement, and he grabbed the back of a restaurant check and wrote out an agreement to sell the farm to Lucy for $50,000. A new one was later written to change "I hereby agree to sell" to "we" to incorporate Zemmer's wife. Zemmer had his wife sign the agreement, but told her it was a joke he was playing on Lucy. Lucy offered $5 in consideration once the check was signed, and the money was refused. The following day, Lucy called his brother to put up money for a stake in the farm, and later had his attorney look at the title of the farm. When Lucy came to Zemmer to close the deal, Zemmer indicated he was not selling his farm. Outside of the facts, what procedural setting do we want to take note of here? Knowing procedural setting can help us understand the core issues of the case, why certain arguments are being made on each side, and what the court is really here to decide. Here the posture is to note that Lucy, who is the plaintiff, sued Zemmer, the defendant, for specific performance of the contract for Ferguson Farm. This means he's essentially asking the court to enforce the contract on the bar check. The trial court ruled in favor of Zemmer, and Lucy appealed to the Virginia Supreme Court. The main issue the court was deciding flows from those procedural actions in the trial court. The central issue on appeal was to decide whether or not the contract on the restaurant check was valid and enforceable for Lucy. Now to rules, the meat and potatoes of the case brief. Identifying the rule or rules the court wants to use and make their decision and understand the court's analysis. This can be the most difficult part for many new law students, so spend some time here and really focus on what rules the court bases their holding on and how they apply that rule to the facts. Here in Lucy, the main rule cited by the court revolves around manifestation of intent in forming a contract. The court cites to both cases and restatements of contracts. It's important to note that a restatement is not binding law, but the court often cites them as support in their opinions. If these come up in class, look to your professor for guidance on how he or she wants you to work with restatements. So what's the rule here? Some language from First National Bank v. Roanoke Oil Company is the best guidance in this case. Quote, "We must look to the outward expression of a person as manifesting his intention rather than to his secret and unexpressed intention. The law imputes to a person an intention corresponding to the reasonable meaning of his words or acts and acts." Also, some language from the restatement is helpful. Restatement of Contracts, Section 71 says, "If the words or other acts of one of the parties have but one reasonable meaning, his undisclosed intention is immaterial except when an unreasonable meaning which he attaches to his manifestations is known to the other party." So how does the court apply these rules? In thinking of outward expression of a person manifesting his intent to enter a contract, the court reasons that Zemmer's unexpressed position that this contract was a joke is not relevant. At no point did Zemmer indicate that he was not serious about selling the farm, and they had talked for nearly 45 minutes about it. Not until after the document was signed and money was offered in consideration was there ever talk about the deal being a joke. Lucy took Zemmer's actions as intent to sell the farm, and a reasonable person would believe Zemmer was interested in entering a real agreement. Finally, the parties settled upon a price that was fair market value for the farm. So the court concluded that the writing on the check constituted a valid binding contract of sale between the two parties and held that Lucy was entitled to specific performance of Ferguson Farms. Now, while this case did not have a concurring opinion or dissent, it's important to look for them and take note of ones published in your case books. They're included there for a reason. So how did this go for you? If you got most of what we went over, great. Build on that. If your brief was a disaster, like the first one I ever did, don't sweat. This is a process. Anyone who tells you they perfectly briefed each case every time in law school, well, they're lying to you. Law school is hard, but the more you work on these fundamentals, it becomes easier. So that's it for case briefing. You're all equipped to go off and brief your cases for the upcoming year and feel totally prepared for the dreaded cold calling. For additional help on briefing cases, use your TAs and AAP leaders in your 1L classes. Now it's time for a quiz.